2024 CR 2594, State of Texas versus Mark Anthony Perez. Could I have parties announced for the record for the state?
Done for the state.
Defense. And are you Mr. Perez?
Yes, ma'am.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand?
Right here, Judge Boyd lays out the charge injury to the elderly, a serious third-degree felony in Texas. That means even though the state recommends probation, the court can still send him to prison for up to 10 years. This is the moment Mark should realize his future hangs entirely on the judge's decision.
Understand you're charged with injury to the elderly, bodily injury. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your
Counsel, has your client been able to provide you with any defenses?
He has.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the prison. State recommends community supervision. They're taking in consideration County Court Cause number 731618. There's an affirmative finding of a family violence, TAP evaluation, follow those recommendations, mental health evaluation, and follow those recommendations, and no contact with Juan Perez. Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. Did you understand those are recommendations from the state and the court does not have to follow that recommendation?
Of course, Your Honor. Understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State law for states 1 and attachments.
Any objection? Have you spoken with the complainant?
We had spoken with the complainant, Your Honor. Yes.
All right, you may continue to confer.
Thank you.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing?
Yes, we'd like to, Judge.
Anything you wish to say on behalf of your client?
Judge, what I can tell you is that Mr. Bettis is under a protective order with his father, that he's been abiding by it. Although there was one minor slip up, his brother actually had a protective order with his father, so he goes to his brother's house, was too close to his father's. But he's very, very much aware of what he can and cannot do, and I think he will comply with the conditions of probation.
Listen closely, Mark is opening up about his mental health struggles. This isn't just small talk, and court details about mental health and medication history can shape probation terms, treatment requirements, and even sentencing outcomes. But notice how the judge is probing for specifics. Vague answers can hurt his credibility.
All right. So, do you have any prior mental health issues?
May I say it?
Sure.
Before I was incarcerated, my parents, I understand, my mom, mean, I was getting in the past, I was getting help at the Center for Healthcare Services for my, like, not that I was on Risperdal, just for anxiety. But I didn't get to do that before. So that's that.
He was having difficult. He's talking about the day of the incident, Judge. He was having a difficult time.
All right. So, other than anxiety, have you ever been diagnosed with anything else?
No.
All right. When's the first time you saw a doctor for mental health issues?
This is a pivotal warning from Judge Boyd. She's making it crystal clear if Mark isn't honest about his drug use, now he'll face harsher consequences later. Judges often prefer complete transparency early on. It shows accountability and can be the difference between rehab and prison.
2024, I was saying, I was in 2021.
So how old were you then?
I was 32.
All right.
36.
Okay. Drug use.
I've been clean for the last 2 years, please.
Well, whatever. I understand. I'm trying to figure out history here. So you've been clean for the past 2 years. What have you been clean from?
Alcohol.
And what
drugs.
else? What type of drugs?
I was just smoking marijuana.
All right. So here's the thing. I'm trying to set conditions for you. I don't do cookie cutter conditions because I want people to be successful. But if you're not honest with me about what you use, what's going to end up happening if you'll be sent off in the world unprepared. And then when you come back to court, which you probably will on a motion to revoke, you're going to want to tell me everything about your life at that point. So it's best that you tell me now. So alcohol, marijuana, what else?
That's it.
Okay. All right. Anything else?
No.
All right. I'm going with the alcohol and marijuana. And so nothing else had better come up in your system.
Yes, ma'am.
All right. The court is finding you guilty. Do you have any children?
I have one son. He's 12.
All right. And who does he live with?
He lives with his mother.
When's the last time you saw him?
3 months ago.
All right.
3 months.
3 months ago. All right. As previously stated, court is finding you guilty. The court is going to sentence you to 2 years in the prison, suspended and probated for 3 years. Take in consideration 731618. There's an affirmative finding of family violence.
That's right.
There should be a TAP evaluation. How long is the MIC in custody?
That's probably about a month.
All right. There should be a TAP evaluation in custody and out of custody.
To go through the whole process.
All right. So we'll do a referral to Center for Healthcare Services. If there's some issues with that, Ms. Abrams, then we may have to take it into custody and do the mental health evaluation at that point. So when they give you the referral for Center for Healthcare Services, you had better go.
Yes, ma'am.
Otherwise, what's going to end up happening is you may end up waiting for 30 or 45 days. You understand?
Yeah. Miss Kate, may I say something?
Sure.
That's the first thing I'm gonna do as soon as I'm released.
All right. There should be regular reporting
Yes, ma'am.
by Zoom or in person.
Sure.
The UA hotline until further notice. There should be no contact with Juan Perez.
Yes.
There should be no unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once he completes those, the community service hours will be deemed satisfied. There should be 90 sober meetings in 90 days. Field visits, 1 time per month. For 3 months after he has received documentation from Center for Healthcare Services. So once he gets documentation for Center Healthcare Services, then 3 months for field visits, then as probation deems necessary. When's the last time you had employment?
So, 2023.
So how you been supporting yourself?
I have jobs that are under the table.
All right, so we're not going to do under the table in here, all right? So
I have a job waiting for me as soon as I get out here. I'm
There's-
going to work at the Red Bar Steakhouse for the 5th time as a chef there.
all right. So proof of employment within 30 days.
Yes, ma'am.
There should be no employment as a home health care provider or with minors.
Yes, ma'am.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am. Thank you for understanding and bringing me just like that's
Okay. Court reporter is not picking up what you're saying because you're mumbling.
Thank you for everything. Thank you, Your Honor.
All right, you're
I
welcome.
understand.
All right, we can go off the record. Here's the thing, to be successful in this court, when you're on probation, communication is key.
Yes,
If
ma'am.
there's an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court.
Thank you very much.
You're welcome. Good luck to you.
Judge, let me just clarify for him so he'll understand. A TAP evaluation in custody, is that the court's order?
Yes.
So what that means is you have to stay in jail until they come and do the evaluation. And then they'll be released.
Yes,
Because the only holding him in the jail right at this point, Judge, is the case that's getting dismissed.
yes. So you'll be in custody. The TAP evaluation, they'll have that done. They're telling me in about 2 weeks, and follow the TAP recommendations. If there's an issue, if TAP recommends inpatient treatment, then your attorney can come back and we can have a discussion about that. All right. Is there anything else?
Now things take a turn. This is a probation violation. Hearing Mark has admitted to using illegal substances, and in legal terms, pleading true means he's accepting responsibility for breaking probation conditions. At this point, he's at the mercy of the court, and the judge could send him straight to prison.
All right. Thank you. You're Mark Anthony Perez.
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Mark Anthony Perez who was placed on community supervision in 2024 CR 2594 for the offense of injury to the elderly with bodily injury on May 28, 2024 for a term of 3 years? Is that you? All right, state.
Yes, Your Honor, we're here this morning on state motion to revoke community supervision. Violation condition number 2, on or about the 9th day of September 2024, in Door County, Texas, the defendant, Mark Anthony Perez, the Defendant, illegally used a controlled substance, namely methamphetamine, violation condition number 2. Waive all other violations.
To that, how do you plead? True or not true?
True.
All right, any objection to the state's waivers?
No objection.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 2 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
But there is, Your Honor, 2 alternate conditions of probation for the potential including DDRF and a mental health evaluation. Zero tolerance on any contact between the defendant and the victim of the case. And the state will also be CIC, a new case of as of 2025 CC 00266.
That is our agreement, Judge.
And what is that cause number? What is the offense?
Violation of the
Victim is his dad.
Judge Boyd isn't just enforcing the law here, she's delivering a reality check. No contact with the victim means exactly that. Zero exceptions, emotional excuses, even family emergencies don't override court orders. This moment is all about boundaries, and Mark's failure to follow them is a huge red flag.
Well, I mean, I said in the order that there's not to be any contact. So what is the confusion?
Yeah, I should respect him because he's my father.
No, I mean, if you respect your father, you don't hit your father. That's what you're on probation for. So I don't know why I should follow your proposed agreement, because he's violating the court's orders, and one of the court's orders is no contact.
Yes, Judge.
So
We've talked about that as well, Judge. I believe it's already been adjudicated as a 2-year underlying, and he's aware of that. And that's actually something he did want to do as well, Judge. So
no, but when I tell people no contact, I am, yes.
We did contact the victim in the case this morning again. He has been that he feels he needs in order to deal with that. That's why he's taking the condition.
All right. So I still don't understand what you don't understand what no contact means. Because here's the thing, if you respect your father, then you don't hit your father. Hitting your father is not showing respect to him. Yes. And then you come to me and I tell you no contact, and I'm usually very detailed when I say no contact. And I know I was very detailed with you when I said no contact, and you said you understood. So I don't understand why you're disobeying the court's orders.
I was just going through a lot. I'm still going through a lot.
Instead of revoking probation completely, the judge is altering the conditions, ordering inpatient treatment, and referring Mark to felony drug court. This is essentially his last lifeline. If he fails here, the next stop is prison, no negotiation.
A lot of what?
My mom almost died.
Okay.
you know, that's, I mean,
No, and I feel sorry for that's happening to you, but that doesn't equate to contacting somebody that you injured.
Your Honor, I believe his mom had a stroke.
second stroke.
And he said that he was, wanted to make sure she was okay, and he was understanding that.
Even my distance, I was only visiting when my dad was at work. I mean,
No, they're saying you made contact. So that's what that cause number is about. It's not I'm visiting while my father's at work.
Your Honor, we understand. In that case, since, you know, they're willing to take that into consideration. But if not, then we'll go through the proper channels. But they're asking him, and his dad's asking him to get him. So that's why we agreed to the order.
Well, that's going to be an inpatient help. All right. So it's saying that he's tested positive for meth in the past.
Our understanding, Judge, that the wait for the DDRF is 26 weeks.
Mm-hmm.
That the facility itself would be in there for 4 to 6 months.
Mm-hmm. So I'm going to deny the motion. Alternate amend conditions. He's going to go to safety, or you can also do a referral to felony drug court, and that's going to be while in custody.
And Your Honor, if he decided to ask you to revoke his probation, what would we have to do to do that?
Oh, would you like to be revoked? The most I can sentence you to is 2 years. The least I can sentence you to is 2 years.
no, I don't want to give it time.
So
I'm
you
sorry,
want to go
what?
to safety?
Yes, ma'am. All right, yes, sir.
All right, so the court is going to deny, thank you. Court is going to deny the motion, alternate amend conditions to include mental health evaluation in custody, referral to felony drug court in custody. If he's not accepted in felony drug court, then he's going to safety. And is there anything that you do not understand when I say there's to be no contact?
Yes, Your Honor.
No, do you understand?
Yes, Your Honor.
All right, good luck to you.
Okay.
I have one question.
Sure.
On the DDRF, it's what's the time frame on that?
She's sending you to safety.
28 weeks.
Okay, the CP, I mean,
9 months.
Yeah.
CP's not, so I have to wait 9 months to go.
No.
No, not 9 months to go. That's the length of the program.
Is there a CP in San Antonio?
But ask you if you want to do it.
Like to do my claims?
Right. Those are the two options. We're in front of the judge. You can explain.
That's fine. Okay, CP's fine.
Okay.
All right, thank you.
Have a seat.